Dear students, the name of the chapter is Government of India, Democracy, Indian Union, and we studied that there are three basic pillars of Indian Union. First is legislature, second is executive, and third is judiciary. We have studied legislature and executive. Today we will study judiciary, and when judiciary comes in Indian Union, then first of all we consider Supreme Court, and the first point is number of judges. Initially there were 7 judges and 1 Chief Justice in the Supreme Court, but as the size of the country increased, the number of judges increased. By 2008 there were 31 judges in the Supreme Court and there was 1 Chief Justice. Now the system of appointing the judges has also been changed. The Supreme Court judges are appointed by the President of our country, and initially he used to appoint the judges by the advice of the Chief Justice of the Supreme Court, but now there is a collegial system. In the collegial system, Chief Justice of the Supreme Court along with some judges prepare a panel and write some names in that panel of eminent lawyers and judges of the High Court. President of our country can appoint Supreme Court judges from that panel or list. Now, qualification of judges. The judges of the Supreme Court has some qualifications. He should be the citizen of India. He should be working in the capacity of High Court judge or any other court for a period of 5 years. He should have worked for a period of 10 years as a lawyer in High Court or any other court of Indian Union, and he should be an eminent jurist in the opinion of the President. Such persons can be appointed as the Supreme Court judges. Third is impeachment. The retirement age for the Supreme Court judges is 65 years. When he attains the age of 65, he retires himself, and before that, if he resigns or if he dies, then he leaves his seat. And if he misconducts or if he shows any inability, in that case he can be impeached by the Parliament by the majority of both the houses when such proposals are brought before the Parliament. Immunities. Supreme Court judges have some immunity, and the most important immunity they enjoy, their decision cannot be criticized and their actions also cannot be criticized. Chief location, according to Article 130, the chief location of Supreme Court is New Delhi. Restrictions on judges. There are certain restrictions on judges of Supreme Court. They cannot work after the retirement in any court of law or as an advocate. They cannot practice as an advocate and against the government. Jurisdiction, powers and functions. The jurisdiction, power and functions can be classified in this way. The first is original jurisdiction. Original jurisdiction of Supreme Court is divided into 2 categories. First is original unit jurisdiction. Second is original concurrent. Original unit jurisdiction is the power and function, main power and function of Supreme Court. Any dispute which is between Government of India and any other state will be heard by the Union Supreme Court only. Any dispute between Government of India and Union Territory of India will go to the Supreme Court. Third, any dispute involving 2 or more than 2 states or Union Territories or involving any constitutional interpretation or matter would go directly to the Supreme Court. In the second case, original concurrent jurisdiction, in this case, the Supreme Court is the guardian of the fundamental right, and High Court has also been given the power by the Constitution to hear such cases. Now, such cases first of all go to the High Court against the fundamental rights. If any fundamental right is breached by any government, then first of all it goes to the High Court, then it can be appealed in the Supreme Court. And if there is no High Court in a particular state, in that case such persons can directly go to the Supreme Court. Appellate jurisdiction, as per the Constitution, Supreme Court is the last appellate court in our country, and appellate jurisdiction can be divided into four categories: constitutional, civil, criminal, and special. Constitutional matters, when there is constitutional matter brought before High Court, and if High Court decides the constitutional matter and the parties are not agreeing with this decision, then they can go against this decision to the Supreme Court. They can appeal in the Supreme Court, and Supreme Court is the final court to decide the interpretation of the Constitution. Supreme Court has the power to interpret the Constitution, and such cases, such appeals would go to the Supreme Court. Similarly, in the civil cases, criminal cases, if capital punishment has been given in the High Court, parties can appeal in the Supreme Court. And civil cases, any case against the appeal, against the decision of the High Court, person can appeal in the Supreme Court. And if in the special jurisdiction, which comes under Article 136, if any case which is not in any of these categories, constitutional, civil, and criminal, such type of cases, if the involvement of Supreme Court is necessary, then such cases in which decision of any court, any High Court of the state or any tribunal, such appeals can be heard by the Supreme Court, but except military court or military jurisdiction. Under Article 136, authority to grant special order for appeal. This is also the right of the Supreme Court, that any court or such type of tribunals, appeals against such courts and tribunals can be heard by the Supreme Court, except military courts. Advisory jurisdiction, in this case, in this category, Supreme Court has the power to advise the President of our country, and President has power to seek advice from the Supreme Court. If Supreme Court gives advice to the President, then President is not bound to follow that advice. It is the discretion of the President to follow or not follow such advices. Court of record. Supreme Court serves as a court of record. All the cases of the Supreme Court and other high courts are recorded in the Supreme Court, and they are used by the advocates in the decision of different disputes. Savior of fundamental right. Supreme Court is the savior of fundamental right, and for that Supreme Court gives 5 writs. Our Constitution gives 5 writs, and Supreme Court uses these 5 writs to provide fundamental right to the people, and these writs are habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Last but not the least, judicial review. This is a very important point, and this makes Supreme Court very powerful. If union legislature or state legislature makes any law which is against the fundamental rights, which overrules the fundamental rights of the common citizen, then such laws can be made null and void by the Supreme Court. This is complete, and this way our chapter is complete. Thank you.